consequence 5, the analysis and foregoing consequences fatally undermine the appellant's section 9.4 comparison between, on the one hand, the suggestion it's fanciful the arbitrator will apply Part 2 CRA, whereas on the other hand, at least implicitly, it is guaranteed the English court will apply Part 2 CRA. Again, that comparison can only properly be undertaken once a threshold decision is made as to whether this court in England would apply Part 2 of the CRA on top of the choice of law pursuant to Section 74. Consequence 6, more widely.
But what's the consequence of the submission that there's a triable issue on that? You say the Section 74 point should go to the arbitrator.
It may or may not do. I don't take a position on that. But what I do say is that it undermines this suggestion that the Part 2 CRA rights are cast iron.
I understand that. I'm just seeing where it leads us. Because as I understand your submission, it is the judge was right to send everything off to the arbitrator, and you're drawing our attention to the fact that one of the issues that needs to be decided is the Section 74 question of close connection. I'm simply inquiring, are you suggesting that that is all part and parcel of what has to be sent off to the arbitrator? Or are you suggesting,
no,
hybrid as it were, that the English court should decide that, and then questions of fairness and so on should be dealt with by the arbitrator?
No, my position is that the stay should be upheld and the English court shouldn't be deciding anything after today. And so the English court shouldn't be deciding the Section 74 issue. But what I'm having to engage with are, first, my own friend's suggestion that this can all be decided summarily under Part 2 CRA. And secondly, in response to that question, the way in which, whether summarily or a possible Section 9.4 trial, the comparison will pan out as between Mr. Soleymani's rights absent an arbitration agreement and Mr. Soleymani's rights in the event of an arbitration agreement. But what I'm not doing is saying that the Section 74 analysis necessarily arises before the arbitrator. And what I don't accept is the corollary of that, if this is where it's going, namely that because the Section 74 analysis doesn't automatically arise before the arbitrator, there must be a Section 9.4 trial here. That doesn't follow. I'll come back to that. Because one also has to look at fairness in a broader spectrum, and there are aspects of fairness that are already before the arbitrator, which overlap with the issues under Part 2 CRA. They don't arise in exactly the same way, because at least in the motion to dismiss, their points taken on the merits, but they go to the fairness of terms and conditions.
I understand that. Part of the reasons the judge gave for exercising the discretion in the way she did was an ability of the New York arbitrator to decide questions of fairness.
Yes.
But the consequence of the submission you've been making on Section 74 is that one also needs to consider the appropriateness of the New York arbitrator deciding the Section 74 threshold point.
Yes.
And I don't think the judge addressed that at all, did she?
No. From our side, the recollection is that she wasn't shown Section 71, and the Section 74 point goes hand in hand with the Section 71 point. And so, no. But it said she was shown Section 71. It's anyway not in the judgment. And so those 2 points do go hand in hand for the present purposes. But I'm not committing that the Section 74 analysis will be undertaken by the arbitrator. But I say that that is neutral on the question of whether the court should uphold the discretion or exercise the discretion afresh in the same way.
Sorry, you're not submitting that the Section 74 question should be...
No, I'm not
determined by the
committing. I'm not committing to that being an issue that falls to be decided by the arbitrator. What then has to happen is that before the arbitrator there has to be an analysis of the extent of the applicable law, including mandatorily applicable laws. The other side have argued that Part 2 CRA applies. They've relied upon, we saw it yesterday in the stay, mandatory UK consumer rights laws. And I'm not conceding that they apply before the arbitrator. But I am saying that nonetheless, similar questions of fairness are clearly an issue before the arbitrator under the properly applicable New York law.
Well, I understand that, but you are protecting your position in the arbitration, as it were, to argue that English law has nothing to say on the question of the governing law, so far as the arbitrator is concerned, even if there is a close connection with this country and would be for Section 74 purposes if the English court were deciding it. Is that fair?
Yes. Consequence 6. More widely, the analysis undermines what we say was the premise of Malone Friend's approach to the Section 9.4 comparison and much of his case on Part 2 CRA, namely that Mr. Soleymani has this inalienable right. And at the end of yesterday, it was suggested that Section 71 was tantamount to a jurisdictional gateway, out of which he cannot contract in any consumer purchase he makes globally, i.e. an inalienable right to the protection of Part 2 CRA. We've seen that it can be contracted out.
Can I just make sure I've understood what you've just said there? If the contract has a close connection, well, I know you say it doesn't, I get that, but if it did, then you can't contract out of it as a matter of English law.
Correct. So we say the relevant principles governing the exercise of the judge's discretion under Section 9.1 and 9.4 of the Arbitration Act should not be controversial, and they're from the Aeroflot case and the Burrito case. I do briefly want to draw out a key distinction as to the court's case management approach, hinging on whether the disputed issues under Section 9 arise under Section 9.1 or Section 9.4. Those are critically different in terms of competence. So we can see that first if we look at the Aeroflot case, which is in Authorities Court 2, tab 13, page 329.
Is the submission that this court has to determine whether it comes within Section 9.1 and the option of sending it off to the arbitration for competence only arises under a 9.4? Is that the submission? What is it? So
it's not that decisive because the same tripartite, the same three options arise under Section 9.1 and Section 9.4, namely this court decides summarily, this court order a trial for this court, or this court stay. Under Section 9.1, the stay has to be under the inherent jurisdiction of the court, because the court has not yet decided whether there is a valid arbitration agreement. Whereas under Section 9.4, the stay is under Section 9.4. But it's about the emphasis, almost a rebuttable presumption. Under Section 9.1, because there's no competence until there's presumptive validity of the arbitration clause, then what the authorities say is that the court must decide the issue itself summarily or at a trial, subject to the possibility of an inherent stay. Whereas under Section 9.4, where you have a presumptively valid arbitration clause and the burden has shifted to show that it's null and void, the logical approach per Lord Justice Aikens is to defer to the court, to defer to the tribunal by reason of competence. So that is a short summary of what we'll see in Aeroflot and in the Burrito. As a difference of emphasis, but one that has substance. Tab 13, page 345, the claimant airline alleged a fraud perpetrated through various companies with whom it had agreements, including 2 governed by Swiss law and arbitration.
345.
Yes, sorry, I'm leaping in past the headnote. The headnote starts at 329. Sorry, of the authorities bundle 2. I'm using the pagination in the authorities bundle. And if one is at page 345, authorities bundle, one should have paragraph 72 of Aeroflot. Mr. Justice Floyd had refused a Section 9 stay, but the Court of Appeal reversed and granted one. And the approach to Section 9 set out by Lord Justice Aikens at paragraph 72 and following shows the 2 different stages, i.e. Section 9.1 first and Section 9.4 second. So at paragraph 73, one picks up on Section 9.1. It seems to me in principle there is a burden on the party asserting the arbitration agreement that there is A, a concluded arbitration agreement, and B, that it covers the disputes that are subject to the court proceedings to prove this. If the party seeking a stay cannot prove both A and B, then there is no jurisdiction to grant a stay under Section 9.1 and 9.4. However, if the court considers that it cannot decide those issues for itself in a summary fashion on the written evidence, it has 2 other options. It can direct an issue to be tried, or it can stay the proceedings under its inherent jurisdiction so that the putative arbitration panel can decide. And then, at paragraph 74, the analysis turns to Section 9.4, where the court shall grant a stay unless satisfied that the arbitration agreement is null and void or inoperative. This means that the party resisting the stay has to satisfy the court that the apparently existing arbitration agreement is null and void. And what we see over the page is that at paragraph 79, Lord Justice Aikens says this in the Section 9.4 context. In theory, I suppose the court could order that there be a trial of an issue to determine whether the arbitration agreement is null, void or inoperative. But if the evidence and possible findings going to the issue of whether the arbitration agreement is null and void or inoperative also impinge on the substantive rights and obligations of the parties, the court is unlikely to do so unless such a trial can be confined to a relatively circumscribed area of investigation. Otherwise, in such a case, where the court is satisfied of the existence of the arbitration and that the matters in dispute are within its scope, so it's got past Section 9.1, then logically the Section 9.4 inquiry must be for the arbitral tribunal finally to decide, assuming it has competence to do so. So that's what in shorthand I've said is the rebuttable presumption. The right course for the court is to grant a stay under Section 9.4 and let the arbitral tribunal get on with determining the dispute. So under 9.4, the presumptive validity of the arbitration agreement combined with the doctrine of competence make deference to the tribunal the logically primary choice. And we say that's also reflected in the burrito, where...
Before we get to the burrito, Mr. Lewis, very small and no doubt stupid question. I'd thought competence was German and had a Z in it. This looks like it's French.
It may be both, and I don't know.
I'm writing a judgment that says it. I just want to make sure I get it right.
For me, more often with a Z, but I don't know who started it. Perhaps I should.
I don't think Lord Justice Aikens' German was as good as his French.
Thank you.
The burrito is in the same authorities bundle 2, 1 tab back at tab 12, starts at page 306. There was a time charter with a London arbitration clause and a key dispute as to the identity of the disponent owners. Was it HIT, as the London arbitrator had held, or genuine, as both HIT and genuine maintained, and as a disputed addendum suggested? So the Charterer's Golden Ocean sought a declaration that genuine was not a party to the Charter Party, and they had no arbitration agreement with genuine. And in the context of service out of those proceedings, your Lordship had to consider how a Section 9 application by genuine would play out, and did so at page 323. The key passage that draws out the principles we say correctly applied by the Deputy Judge is paragraph 59. Today I want to emphasise the distinction it correctly draws between section 9.1 and 9.4. So at the bottom of 323, 59 sub paragraph 5, it's dealing with 9.1. It is for the defendant to satisfy the court that he comes within section 9.1 before the court can grant relief. It is not enough for him to show merely an arguable case. Unless the court is satisfied that he has the arbitration agreement that covers the matters in dispute, there is no jurisdiction under the section to stay proceedings. The court must therefore determine the dispute if it affects the question whether D comes within section 9.1. If it cannot do so on the written evidence, it must direct a trial of that issue before granting a stay under section 9. It may, however, decline to direct a trial of the issue and grant a stay under its inherent jurisdiction without resolving the issue. So on section 9.1, deference to the tribunal is very much the third option, following on from the two apparently mandatory ones. By contrast, in subparagraph 59.6, we switch to the analysis of section 9.4, where the options are assessed in a different way. There are the same three broad options, but your Lordship said, it is for C to satisfy the court that the arbitration agreement is null and void, inoperative, or incapable of having effect under section 9.4. If it is not clear on the evidence before the court whether the agreement is null and void, etc., the court may order the trial of that issue, but is not bound to do so. If it declines to do so, it will be sufficient for D to show an arguable case that the arbitration agreement is valid and effective, because in such circumstances, C will have failed to discharge the burden imposed upon him by section 9.4 of satisfying the court that the agreement by which he agreed to refer the matters in dispute is null and void, etc. And that's consistent with what Lord Justice Aikens said about the logical approach being for a 9.4 analysis to defer to the tribunal. Your Lordship then set out 7 non-exhaustive factors likely to be of significance at paragraph 59 sub 7. They are subparas A to G, all of which have been applied by the Deputy Judge, and we give the references below. So where we are in this case is that it's common ground that my clients get past section 9.1. We are only concerned with the null void, etc. question under section 9.4. So logically, the correct approach, the primary option, as I say it, is to defer to the tribunal consistent with competence. The burrito then makes clear that the court must take into account all the factors. Thus, a factor, and in some cases a key factor, may be the section 9 respondent's status as a consumer or an alleged consumer. That can be a freestanding factor, or it can be taken into account through the prism of the 7 burrito factors set out at paragraph 59, subparagraph 7. But there is no bright line rule that as soon as a section 9 respondent alleges he is a consumer, the 3 options under section 9.4 are reduced to only 2 options, i.e., so the appellant would say summary determination by this court or a section 9.4 trial in the High Court. There is no bright line rule to the effect that as soon as there is an alleged consumer status, competence is ignored, and the court must itself always resolve the section 9.4 issues. Neither section 71 of the CRA nor the CJEU case law foreclose the option of deferring the issues to the tribunal. That wasn't a point taken in the grounds of appeal or in the appellant's skeleton, and rightly so, although it does appear now to be advanced. Insofar as the deputy judge had those 3 options open to her, then she properly exercised discretion in favour of deferring to the tribunal. As I started with yesterday, it's only if there's a rule of law foreclosing the third, we say the logically primary option of deference to the tribunal under section 9.4, that her discretion can be impugned. To show why section 71 CRA does not foreclose that option, I want to start with the Law Commission, which is core 2, tab 26, please. Page 571.
Sorry, can you give me that page again? 561.
571.
571.
The effect at the bottom paragraph at 7.89, discussion. The effect of the CJEU case law is that a court must consider the fairness of a term, even if the consumer does not mention the point. Furthermore, the court must be entitled to find the term is unfair, even if the consumer does not present any evidence. It is important that any new legislation is consistent with this case law. That makes clear the rationale for the ex officio duty in section 71(2) CRA. Namely, it exists where either the consumer does not take the point or does not tender the relevant evidence. Neither rationale applies where the alleged consumer is disputing fairness not only before this court, but also before the tribunal. Secondly, here,
Sorry, just explain to me what rationale are you saying is in here? I mean, I understand it says the conclusion, it says the court must be entitled to do it, but it's not obvious to me what the rationale is.
the rationale, and we'll see it from the case law in a
Okay,
moment,
well, you can show me that, that's all.
is correcting an imbalance that exists where the consumer isn't taking points either by reason of ignorance or because of prohibitive costs. So the short answer as to why, after that Law Commission advice and Section 71's implementation, it does not foreclose the logically primary option under Section 9(4), is because Section 71(2) is not mandatory and can be contracted out of. See Section 74 and what I said either side of the shorter journal. But next I turn to the longer answer as to why that option is not foreclosed, which depends upon a proper understanding of the CJEU decisions on the scope of the ex officio duty.
I mean, you haven't referred us to it, but there's quite a lot of explanation as to the Law Commission's rationale for spelling it all out on the following page, 572, isn't there? Particularly at 794. I mean, that's what this is actually all about.
Yes, yes. Exactly so, and then, I mean, there's detail there on burden of proof point that doesn't end up making it into the legislation as well, but it covers the two. And that is partly based upon the pre-2015 CJ EU case law, which I introduce on the basis it demonstrates three propositions. One, the rationale behind the ex officio duty is equality of arms, i.e. to correct the imbalance affecting consumers due to ignorance or prohibitive cost. Proposition 2, the procedure to adopt in the event unfairness of a consumer term may be an issue is a matter for the national legal order, subject only to the principles of equivalence.
Sorry, could you just stop that one? The procedure for...
The procedure to adopt in the event unfairness of a consumer contract term may be an issue is a matter for the national legal order, subject only to the principles of equivalence and effective judicial protection.
Sorry, are you talking about something under the regulation?
I'm setting out the three propositions that we are going to see from the CJEU case law on the Unfair Terms in Consumer Contracts Directive, which inform the interpretation of Part 2 of the CIA. So Proposition 2, the procedure to adopt in the event unfairness of a consumer term may be an issue is a matter for the national legal order, subject only to the principles of equivalence and effective judicial protection. Proposition 3, provided it does not contravene those two principles, a national law may preclude consideration of the fairness of a term by the national court, and indeed its consideration at all. Yesterday you were taken to Oceano Gruppo, supplemental bundle tab 9, the short point I want to emphasize is on page 118. That grounds my proposition 1, the rationale here. The aim of Article 6, we're at paragraph 26 of the decision, bottom of page 118. The aim of Article 6, which we saw earlier, is to lay down unfair terms are not binding on the consumer, would not be achieved if the consumer himself were obliged to raise the unfair nature. In disputes where the amounts involved are often limited, the lawyer's fees may be higher than the amount at stake, which may deter the consumer from contesting the application of an unfair term. While it is the case that in a number of member states, procedural rules enable individuals to defend themselves, there is a real risk that the consumer, particularly because of ignorance of the law, will not challenge the term pleaded against him on the grounds it is unfair. So the rationale for what at that stage is described as a power to evaluate is that twin danger of prohibitive costs or ignorance. Next, please, the Mostazo-Claro case.
Just before you, I'm just trying to think that through. The reason why, is this right? The reason why those are rationales for the court's power is because the conclusion isn't only relevant to the individual consumer in the case, but is relevant to the class of consumers that relates to. That's why this matters.
That's not said by the CJ.
I know
It is. It's said at the end of 28, isn't it? Said at the end of paragraph 28. Sorry, do I?
No, fine. I certainly seem to follow, but if it's said,
It's. I'm corrected. I'm grateful. Yes, the precedent value is part of it at 28. I do accept that. I apologise. But the primary rationale is obviously the instant consumer being either potentially ignorant of the rights or deterred by the costs. Mostazo-Claro is core tab 2. Sorry, core authorities 2, tab 15, page 408. The consumer in this case had argued the arbitration on the merits, lost, and then the consumer applied for annulment, at which stage she challenged the fairness of the arbitration clause. We turn please to paragraph 24 in the judgment, which is page 422. There emerges what I put as proposition 2, the detailed procedural rules designed to ensure the protection of the rights which individuals acquire under community law are a matter for the domestic legal order of each member state, provided that they are not less favourable than those governing similar domestic situations. That's the principle of equivalence, and that they do not render impossible in practice or excessively difficult the exercise of rights conferred by the community legal order. That's the principle of effectiveness or effective judicial protection. And that's why we'll say in a moment that the operation of section 9.4 is a matter for the English national order. Paragraph 29 reiterates the twin rationale, the primary rationale, I say, of correcting inequality of arms. And then in paragraphs 30 and 31, the court held that the assessment of fairness there could not be precluded on the technicality that the consumer had not taken the point during the arbitration, but only on the annulment. You were then shown the Panon case at tab 16, core authorities. That starts at page 425. And in particular, passages on page 437. Paragraph 32 has as its premise, we say, that the court seized, those are the opening lines, must ensure the effectiveness of the protection. That's the principle of effective judicial protection we've seen. And that, in part, justifies the ex officio obligation to consider the fairness of the term. The instant context there was the Hungarian court assessing which intra-Hungary court had territorial jurisdiction. Because Mrs. Gorfie, who was on invalidity benefit, lived 275 kilometres from the chosen court, and there was no direct public transport link. And I accept that paragraph 34 does tend to suggest that national procedure for determining jurisdiction must not in any way impede effective judicial protection. But I say two things. A, that is diluted by the subsequent jurisprudence, as we will see. B, it begs the question of whether a particular procedure is impeding effective judicial protection. And then at paragraph 42, the court reiterated a point from Oceano Dupar that the application of the general criteria in the unfairness test must be considered by the National Court in the light of the particular circumstances of the case in question. So my learned friend says, well, the CJEU cases are all very brief. That's because they don't descend into the facts, most of the time at least, of the particular cases, because it's a matter for the National Court to apply the fairness test if it arises. The next case is tab 17, core authorities, page 442. Sturcom versus Rodriguez. And I do say that the CJEU immediately rode back from what, on one interpretation, Panon had said about national procedure. In this case, the ex officio duty did not arise where it conflicted with a reasonable national rule as to res judicata. So, page 445, again, a mobile phone provider had an arbitration award against the consumer. Paragraph 23, the arbitration award had become final because Mrs. Rodriguez had not initiated any proceedings for annulment. Asturacom at paragraph 24 brought an action for enforcement of that final arbitration award. Paragraph 25, the Spanish court considered that the arbitration clause was unfair. However, that did not have any impact. Paragraph 27, the question was, is it necessary for the court hearing an action for enforcement of the final arbitration award to determine of its own motion whether the arbitration agreement is void and accordingly to annul the award, if it finds that the arbitration agreement contains an unfair arbitration clause? When we then turn over the page, paragraph 33, the court distinguished Mrs. Rodriguez's case from that of Mostaza Claro, in that Mrs. Rodriguez did not in any way become involved in the various proceedings, so that, final line, the award now has force of res judicata. Paragraph 38, the rules implementing the principle of res judicata are a matter of national legal order. Those rules must not be less favourable than those governing domestic actions, principle of equivalence, nor framed in such a way to make it in practice impossible or excessively difficult to exercise the rights conferred by community law, principle of effectiveness. Paragraph 39 then considers the principle of effectiveness. The court has already held that every case in which the question arises as to whether a national procedural provision makes the application of community law impossible or excessively difficult must be analysed by reference to the role of that provision in the procedure, its progress and its special features viewed as a whole for the various national bodies. Account must be taken where appropriate of the basic principles of the domestic judicial system, such as protection of the rights of defence, principle of legal certainty and the proper conduct of procedure. And what we do say is that if, as the appellant needs to do, it is to foreclose the option of deferring to the tribunal under section 9.4, where an alleged consumer is involved, then this is the inquiry under the principle of effectiveness, that it must say that actually that three-way option under section 9.4 in the context of a consumer impedes the principle of effectiveness. Paragraph 40, the arbitration award had become final because it had not been challenged within the time limit. Paragraph 42, the time limit was 2 months. Paragraphs 47 to 48. In any event, the need to comply with the principle of effectiveness cannot be stretched so far as to mean that in circumstances such as those in the main proceedings, a national court is required not only to compensate for a procedural omission on the part of a consumer who is unaware of his rights, as in Mostaza Claro, but also to make up fully for the total inertia on the part of the consumer concerned, who, like the defendant in the main proceedings, neither participated in the arbitration nor brought an action for annulment of the arbitration award, which therefore became final. So notwithstanding the Spanish court thinking the arbitration clause was unfair, it could disregard that consideration and enforce the arbitration. That is an example of a member state court not being obliged to assess fairness, even where the point had not been taken by the consumer, and the court did consider the agreement unfair, because national procedural rules on res judicata provided to the contrary. The court then go on to consider the principle of equivalence at paragraph 49, and that only requires the court to assess fairness if it's also required to assess fairness at the same time in a domestic situation, or by reference to domestic rules of public policy rather than the Unfair Terms in Consumer Contracts Directive.
I mean, that's what's slightly bothering me about this submission. I can understand the submission that UK law didn't have to provide Section 71 in the terms that it did, because this shows that it didn't have to be as stark as that to comply with European law. But the question is, what does Section 71 mean? Not what European law would have allowed it to mean. And 71 is pretty mandatory, isn't it? If there's a close connection and it therefore applies under Part 2 and so on and so on, Section 74 applies and all of that, it's mandatory.
The questions aren't so separate, because we say what Section 71 means should be interpreted by reference to the CJEU law upon which it's based. It is, after all, pre-Brexit implementation of the directive.
Right.
And so, in circumstances where, as the CJEU says here, national procedural rules do not always have to be subsumed by the ex officio duty, that is relevant to what Section 71 means. And we say Section 71 does not ride roughshod over all other national procedural rules, such as the Section 9(4) discretion, and does not therefore have the effect that the appellant needs it to have, namely to say that the deputy judge actually only had two options: summary determination or a Section 9(4) trial here.
But it's not that Section 71 is riding roughshod over 9(4). It's that the effect of Section 71, properly characterised, is something to be taken into account when exercising the discretion under Section 9(4).
Well,
isn't it?
That is a watered down point compared to what I say is necessary, namely, in order to impugn the discretion, I say it's necessary to say that the option of deferring to the tribunal didn't exist at all.
Well, I understand that. I've been wondering throughout these submissions whether you're really putting up an Aunt Sally, and whether it really is necessary in order for us to interfere with the judge's decision for that to be the case, because as you've illustrated, one of the considerations is that the New York arbitrator will not, or at least may not, apply the same principles as the English court would apply to determining the operability of the arbitration clause. And that doesn't seem to have performed any part of the analysis that I undertook in the Burrito, and I think also in Aeroflot, where when one was talking about leaving matters to the competence of the tribunal, one was assuming that the tribunal would apply the same principles as the court would apply to the arbitrability question. But the reason I'm suggesting that it may be an Aunt Sally to say we can only interfere if the position is that referral to the tribunal was completely ruled out, is that it doesn't seem to me that the judge gave any weight or took into account the fact that the New York tribunal might not decide the arbitrability question, or the enforceability question, on the same principles as the English court would apply. Now, I may be right or I may be wrong about that, but if I'm right about that, then you are putting up an Aunt Sally, aren't you?
Well, if I'm putting up an Aunt Sally, it has the impact that all three options are on the table before the deputy judge and are on the table today. So that in itself is a proposition I'm happy to have established. One then gets to the question of whether there is a separate basis to impugn her discretion, which is so it would seem failure properly to take into account section 71, which, as those behind me recollect, it wasn't suggested to her she should take into account. Of course, one possible basis to impugn the exercise of discretion is if an important factor has not been taken into account. But what we say is that there is enough in the judgment, I'll come back to this, to say that equivalent considerations have been taken into account when applying the 7 Burrito factors that it was common ground the deputy judge should apply, albeit with the prism of consumer coming into them. So even if I don't need it because of the Aunt Sally, then I use it anyway to say that section 9.4 remains entirely open as to all three options. The logically primary approach is the approach the judge took. And one then, even if at the third stage this court is exercising a fresh discretion, then it is not fettered in any way, and it should exercise it with the same result as the deputy judge did.
And just while I'm on it, what you describe as the logically primary position derived from Aeroflot and my judgment in Burrito, that doesn't come from, in either case, does it? A consideration in either of those cases of what you say is the position here, namely that the tribunal won't apply, or may not apply, the same principles as an English court would apply to the section 9.4 question.
I don't recall that being a particular point on the facts.
I'm reasonably confident it wasn't in the Burrito, but looking at what I said in the Burrito in relation to the extent to which you can rely on the tribunal, I think on the last of the 7 factors, rely on the tribunal to get the answer right, presupposed that the question that it was asking itself was the same question as the English court would be answering under section 9.4. What's unusual about this case is that, as you've identified for section 74 purposes, if for no other, you don't accept that the arbitrator will be applying the same principles.
2 points. First, on the one hand, similar to Burrito, that cannot have been a consideration in Aeroflot because the court did decide the issues by reference to Swiss law in this court, which is the law that was in the arbitration agreement. So it would seem to follow, as your lordship identifies, that there wasn't that potential disparity. But secondly, on the other hand, we don't accept that that is decisive. We are not in the realm of distinguishing those cases as authorities. We are asking about whether this was the correct, alternatively a reasonable exercise of the discretion on the facts of this case. And on the facts of this case, yes, that potential disparity is one factor, but we say, I'm going to come on to fairness under New York law, it's not significant. the final case is the Cantilevering case, which is in the Core Authorities bundle at tab 19. And it's all broadly to the same effect. In particular, paragraph 32, which re-emphasised that the manner in which to police consumer rights is a matter for the national legal order, subject to the principles of equivalence and effective judicial protection.
Sorry, can you? I must have missed the reference when you gave it.
Sorry, core 2, tab 19, page 473 at page 481. Paragraph 32. But on, my Lord Justice Birss's point about whether any of the CJEU law matters when we've got the CRA, can I please show you Chitty, which is in Core 2, tab 22, and pick that up at page 538. After analysing the case law of the CJEU, in the last 2 lines, the editors say, after explaining that the implicit recognition is that national courts know the law, on the other hand, the laws of civil procedure differ very considerably between member states in terms of the relative roles of the courts and the parties to litigation in the identification of the facts on the basis of which they claim in their characterisation in legal terms. And this realisation forms one reason for the court's acceptance of what is sometimes termed the principle of the procedural autonomy of the member states. While this principle provides the starting point, it then subjects the national rules in question to the double test of the principle of effectiveness and the principle of equivalence. So we say that, this is the last point I'll make in case it is Aunt Sally, that section 9.4 is a matter for the procedural autonomy of the UK and no option is foreclosed. On taking into account the English case law, sorry, the European case law, we then have at 40-394 analysis of section 71 of the Act. It's quoted over the page. There's then focus upon the separate indication by the CJEU in the 2020 case of Lintner that the court might itself undertake investigative measures in order to complete the case file by asking the parties to provide it with clarification or documents necessary. And what is then said is, as a matter of retained EU law, in principle a UK court would be under a duty to interpret section 71, if possible, so as to conform to this interpretation of the law, but it may be doubted whether the clear words of section 71 can be so interpreted. Moreover, after IP completion day, the Supreme Court and listed appellate courts have the power to depart from this retained EU case law. Such a decision could be appropriate on the basis that the interpretation of the extent of court's duties adopted in Lintner is incompatible with the clear words of the 2015 Act and with fundamental principles of English civil procedure, according to which it is for the parties to adduce evidence of facts rather than the court. Now, I don't rely upon that passage for what it's saying about the duty to investigate. But what I do say is when we're interpreting section 71(2) and the ex officio duty, we do so by reference to the retained CJEU law, including in particular the 2009 case of Sturscon, which shows that the national procedural legal order can trump and is a matter for national law. So we do say that Section 9.4 is still fully open. It does not on any view preclude the principle of effectiveness. It allows consideration to be given to consumer or alleged consumer status, as it was by the deputy judge. And in that sense, it's more favourable than the res judicata rules in Osterzicon, following which there was no question of consideration of fairness anywhere. So we say Section 71 affects what the court should do when seized of the dispute, but does not touch the logically anterior question arising under Section 9.4 of whether the court or the arbitration tribunal should be determining the issues, including, broadly, issues going to fairness. And that is all the more so when the alleged consumer has teams of lawyers in both jurisdictions. It boils down to Section 71.2 not being a rule of jurisdiction, not being a rule that trumps the wide discretion under Section 9.4. So our headline submissions on Section 71 remain as summarised in paragraph 55 of our skeleton, supplemented in particular by that threshold Section 74 point. So there may be cases on different facts, low value, undisputed consumer status, where that weighs heavily in favour of the court summarily determining the unfairness of a term, including if there's clearly a close connection with the UK. There may be cases on different facts where the burrito factors, coloured by the consumer's status and his or her barriers to contesting the arbitration overseas, weigh heavily in favour of having a Section 9.4 trial here. The arbitration might be in a foreign language, and there might be difficulties obtaining legal representation there. But assuming the option to stay exists under Section 9.4 in an alleged consumer case, which I say it does, and that may be an art salad, this case was and is a paradigm case for staying the English claims and letting the arbitration run its course without a parallel Section 9.4 trial here. The judge made a correct decision within the range of decisions reasonably open to her. First, she correctly concluded that Section 9.4 raised triable issues that could not be determined summarily, so that takes one option off the table. And we maintain that was correct. That left then the dilemma between a Section 9.4 trial and a stay, and the judge correctly, alternatively reasonably, exercised her discretion in favour of the stay. I do want to support her decision not to determine summarily the issues. Briefly, in addition to paragraphs 45 to 47 and 61 of our skeleton, 3 tribal issues. Is the appellant a consumer at all? 2, does the consumer contract have a close connection with the UK? And 3, is the arbitration agreement unfair under the CRA section 64.2 if that test falls to be applied? As to whether Mr. Soleymani is a consumer, i.e. was acting for purposes wholly or mainly outside his trade, business, craft or profession, that is triable as an inherently factual question in a nuanced context of speculation on crypto assets, where Mr. Soleymani describes himself as a well-known art collector who owns an art gallery. My learned friend sought to re-emphasise yesterday the private and personal nature of Mr. Soleymani's art interests, including his alleged private gallery. The website for Mr. Soleymani's art gallery, which is in the public domain, and which is called Adelia, says, at the moment, and while our physical gallery is getting a facelift, we are operating online, and our online shop is at Artsy. The website has a shopping cart function, has a refund policy, which says all items are final sale. When one hyperlinks to...
This isn't in the evidence, is it?
It isn't, but nor was the material my learned friend put in yesterday.
Not the same reaction that I gave
Well,
yesterday. I hope I've been consistent.
The position is that the gallery sells...
With great respect, the evidence about the gallery was in his witness statement in paragraphs 19 and 19b.
What, this evidence we're now hearing?
What I am reinforcing is the triable nature of the consumer status as alleged of Mr. Soleymani. To dispel the submission maintained that that should be summarily disposed of. Mr. Soleymani makes numerous factual assertions to try and cement that consumer status, notwithstanding the extreme facts of this acquisition. And what's complained about, aside from the concession point, is that Nifty should have brought forward its evidence to enhance the court's ability for summary determination. That misses the point that there are triable factual issues on which Nifty is entitled to test his evidence. We do say it's also perverse if the very act of bringing a Section 9 application saying don't hear claims, including the Part 7 claim relating to the validity of the arbitration agreement, leads to their inevitable summary determination under Section 9(4). The second triable matter I want to develop is the Section 64(2) fairness test itself. The extreme facts of this case make that unsuitable for summary determination. I'm grateful to my learned friend Mr. Riley Smith for the additional overnight materials on the unfairness test. They reinforce, in particular the chitty section, how the unfairness test is triable. Briefly using the chitty paragraph references in the new bundle he's provided at tab 3, and I don't propose to take your lordships to each of these. Many of the propositions will resonate from, for example, the first instance case. 40-290, it's necessary to ensure the evaluation of all interests involved.
Give me the reference again.
40-290. 40-292, the court should take into account all the circumstances which could have been known at the time of conclusion of the contract. 40-293 and 295 take into account the nature of the goods, services or digital content. 40-294, there is no closed list of considerations. 295, the court can properly consider good industry practice. 4300, the actual vulnerability of the consumer may be relevant. 40-310, the consumer's relative experience in business may be relevant. Those.
Does that mean the relative experience of consumers of this type, or does it mean individual?
We find that passage at page 153 of the bundle, consumer benefiting from advice, well-informed or experienced. So it obviously reflects circumstances that are specific to the individual at the time of the conclusion of the contract, and so would have been reasonably known to both parties and inform, as per my Lord Justice Snowden's examples yesterday, what type of reasonable person one is talking about when one is then applying the two limbs of the unfairness test. Is it a reasonable person out on the strand, or is it a reasonable investor in crypto assets and NFTs, etc.?
I mean, I understand, well, it's not clear to me just looking at this paragraph and glancing at it that your submission is right, that this is about the individual qualities of an individual consumer rather than the class qualities of the relevant class. Just looking at the, turning over the page, line 5, similarly where it is shown that the consumers, plural, were independently wealthy, and so on. That sounds like that's talking about the class, not the individual.
Well, yes, although the preceding example of the professional agent obviously specifies an individual set of circumstances for that particular consumer, and I mean, it is in that difficult interface between what is subjective and objective in terms of defining the characteristics of the reasonable consumer in the position of the particular claimant in a given case. So, fairness, if the CRA test is in play, also entails considering the fairness of the arbitration clause itself. And we do say that Mr. Soleymani's case on that is full of contested factual propositions. As we've seen, the features of Clause 17 include an entitlement for the consumer to claim in the small claims court, and then include the two different streamlined procedures, the streamlined procedure for disputes under $250,000 and the comprehensive procedure only applying where the dispute such as this exceeds $250,000. So one may have to consider, for example, whether streamlined procedure for a dispute that is more than £5,000 but less than $250,000 is actually more appropriate than a Part 7 High Court procedure. One will also then have to consider the JAM's consumer arbitration minimum standards in assessing the fairness of the arbitration clause. We touched upon them yesterday. They're in Core 2, tab 25, page 559. And what they say on 559 is that JAMs will administer arbitrations only if the contract arbitration clause is specified in Popplewell's comply with the following minimum standards of fairness. So if they aren't complied with, then it suggests arbitration is off limits. They include not just procedural safeguards, but at item 2, substantive provision. The consumer must be given notice of the arbitration clause, its existence, terms, conditions, and implications must be clear. They then include, as identified yesterday, the right to an in-person hearing in the consumer's hometown area.
So, Mr. Lewis, doesn't this mean that your clause can't possibly satisfy this? Because what it says is that the arbitration clause has to have these features, and your arbitration clause doesn't have it. Isn't that what the bit you just showed us on the previous page says? Only if the contract arbitration clause complies with the following minimum standards. And the one you just read out is it has to have a right of hearing in your hometown.
But by incorporating the JAM's provisions, it thereby we say incorporates also these standards. Any arbitrations to be settled by binding arbitration held in New York, administered by JAMS. And so where JAMS is administering the arbitration, this is therefore incorporated by reference.
So, where were the wording you just read from?
At the end of the second paragraph, clause 17, so supplemental bundle, tab 3, page 31.
Sorry, and you were reading where? So apparently the clause, to take my Lord's point, in the middle of page 31, you agree that such arbitration shall be settled solely and exclusively by binding arbitration held in New York. Well, that's not compatible with the provision that gives Mr. Soleymani the right to have an arbitration in his hometown area. It's saying it's got to be in New York. Isn't that the point that's being made to you?
I understand how that would be a sub-aspect of it.
Well, that was the point that was being made to you. I don't think it's a sub-aspect of it at all. It said that clause is inconsistent with the requirement of clause minimum standard 5. I don't know where this is going, but I mean...
Well, we say it's not. I mean, that may be a point open to Mr. Soleymani in New York and could be fully argued there. But what we would say off the bat is that where the clause goes on to say that the arbitration is to be administered by JAMS, it was not necessary for it to set out in extenso all of the rights inherent in the consumer arbitration minimum standards.
Yeah, but these aren't the rules. I mean, I asked you this morning about where are the actual rules that JAMS is applying. This is just JAMS saying we won't do an arbitration unless whatever your arbitration provision is, it complies with these terms. As I understand it.
Well, we won't do it if there's a consumer, is what they're saying.
Yeah, we won't do it if the arbitration clause between a company and a consumer doesn't comply with the following minimum standards, one of which is you've got to offer the consumer a hearing in his hometown area. The clause has to offer, the consumer must have a right to an in-person hearing. And all I'm making at the moment, I think the only point that's been made to you at the moment, maybe I've misunderstood it, is that on the face of the actual arbitration clause, it doesn't do that. Well, you say the fact that it's, quotes, administered by JAMS in some way does do it, and I'm not able to join the dots.
Well, we say it does, because we say the administering by JAMS incorporates by reference. JAMS minimum standards for consumer arbitration with which JAMS is refusing to act inconsistently. And therefore, the correct interpretation here is not that, absent all of 1 to 10 on page 560 being set out in extenso in the arbitration clause, it's thrown out. Rather, those standards need to be observed, and they will be if JAMS is administering the arbitration.
So I think is this what you're trying to say? That if we were to look at the JAMS comprehensive arbitration rules and procedures, which are the ones that are applicable for counterclaims over £250,000, yeah, claims over £250,000, we would see in those comprehensive arbitration rules and procedures a right in Mr. Soleymani to have an in-person hearing in his hometown. Is that right? Is that what you're saying? I mean, you can't get there just by the words administered by JAMS. That we've got to look at the actual rules, haven't we?
No, I'm not saying that, and don't say that, because that's not the provision in the JAMS comprehensive arbitration rules and procedures, which provide for the arbitrator to determine where the hearing may be held, including remotely, consistent with those comprehensive rules, also potentially applying to non-consumer disputes. What we do say is that the consumer has the inevitable benefit of the consumer arbitration minimum standards if he or she is a consumer. And I mean, maybe because the arbitration rules haven't been in evidence, and this isn't the point that's been taken until now, we need to come back to you on it. But we don't accept that the arbitration clause can be thrown out by this clause on the basis that the text of items 1 to 10 on page 560 is not set out in clause 70 against the contingency that the counterparty might be a consumer, which of course is disputed. I mean, all of what we're seeing here is that there are other fairness issues that are not identical to CRA Part 2, but that might be invoked by Mr. Soleymani in New York. And that's not a reason to reach a different conclusion from the judge. And the other point on the detail was the point on costs, which I touched upon yesterday, that the item 7 says when the company is the claiming party initiating an arbitration against the consumer, the company will be required to pay all costs associated with the arbitration, which we say in context means the JAMS costs and all of the arbitrator's fees. So that is, when considering fairness of the process, to put it neutrally, going to be a relevant factor.
We also have a definition of consumer here.
Yes.
Which is by no means the same as the definition of a consumer in the CRA, is it?
Well, it's not the same, but nor is it drastically different. There, a consumer is defined as an individual who seeks or acquires goods or services primarily for personal, family or household purposes. Section 2(3) Consumer Rights Act. Consumer means an individual acting for purposes wholly or mainly outside that individual's trade, business, craft or profession. So one comes at it from different ends of the telescope.
I entirely accept that they may have similarities, but they don't seem to me to be identical.
No, I don't suggest they are identical, but I also suggest that if we have another Venn diagram, that the number of parties that would fall within one definition but not the other would be small.
Well, that may be so, but the relevance of this, as I understand it, is that you say there's a triable issue as to whether he's a consumer, but that can be dealt with by the arbitrator, because the arbitrator is going to have to consider that question for the purposes of deciding whether or not these rules apply.
Yes, and for the
But
purpose...
it's not the same question.
It's not exactly the same question, but what we do say is that it's... I mean, there's a risk actually of it being parochial to say it must be our fairness test unless their fairness test is identical. And that's certainly not what the CRA says.
How does that fit with your suggestion that it's for the national procedures to decide on the Section 9 question? Because if that leaves it open to this court to apply its own national principles as to whether it should go down whichever of the three options, then if the third option involves sending it off to the arbitrator to address the question under its competence jurisdiction, if it's not the same question, it's really difficult to see that it's parochial of the English court to say we're going to apply the question under our national rules. Is that parochial?
It is not parochial for the English court to say, if we are determining the question of fairness, then we must apply our conflicts of law rules and our fairness test because they are our rules and test.
Yeah.
But it is, we say, when one is entering into the Section 9.4 discretion with all options on the table, and when one is comparing the pros and cons of a Section 9.4 trial with the pros and cons of the stay in favour of the arbitration, it is parochial to say our fairness test must be better than theirs. When there are overlapping issues and similar considerations are going to be applied. But yes, it's our test, and so it falls for us to assess the question that we must apply our test. But that doesn't make it inherently better or worse, or more appropriate than...
I didn't understand it was a... Maybe I've misunderstood the argument. I didn't understand it was a competition between whose fairness test is better than the other person's fairness test. I thought it was which venue or which person, whether it be an arbitrator or the court, is best placed to apply the fairness test which is to be applied. Have I understood it wrongly?
Yes, because we say that assumes what it seeks to prove, which is we must at all costs have the English fairness test applied, and therefore who is going to apply that or who is going to apply it best, and that's part of my own friend's case. Whereas we say the premise is false, and actually in context it can be partly that question of who is going to apply a particular fairness test. But stepping back, it should more properly be, or at least also be, a comparison of the way it's put in the cases is what the position would be with the putatively unfair term and what it would be without it. And so without it, it would be the English court deciding whether the fairness test under CRA Part 2 applies at all, close connection, and if so, if it does apply, applying the test. With the arbitration agreement, it will be the arbitrator applying potentially that, but I don't concede it. It would seem at least an alternative body of rules that protect consumers, the Jones minimum standards, other aspects of New York law that have been relied upon by the appellant that we're about to look at. And what I don't accept is that when one is undertaking the Section 9.4 analysis of where we go, Section 9.4 stay, Section 9.4 trial or stay, one as an ace in the pack, which is, unless there's a guarantee that the foreign tribunal will apply exactly the same conflicts of law rules and subsequently substantive rules of law as the English court, then it's game over, because we have to have them upheld. We say it's more nuanced than that.
Now I'm confused. There's two different things going on. There's the competence question, if it's the arbitrator deciding whether the arbitration clause is void or ineffective, and then there's the substantive argument about whether the actual matrix agreement, if that's the right expression, the real agreement, let's put it that way, whatever, is fair or not. As far as the competence question is concerned, that's about, is the arbitration clause okay or not, void or not? That only arises if you're applying the consumer protection laws under this jurisdiction. It may be something to be applied by the arbitrator, but it may be something to be applied by this court. But I wasn't aware that there was an argument that the arbitration clause, as a matter of US law, is said to be unfair and therefore unenforceable.
My understanding, and we'll get the references of Mr. Soleymani's position in New York, is he brought the jurisdictional challenge. The arbitrator said, I have competence to resolve this, and then it got kicked off to be dealt with at the final hearing, when it will partly stand or fall with issues as to the fairness of the matrix contract. But
you could
and
imagine.
so, if the conclusion might be at the end of that there was such unfairness pervading this whole consumer contract that it strikes out the claim on the merits for $650,000 and also the arbitration agreement. So I find that the claim would fail, but in fact also that the arbitration agreement falls and I had no jurisdiction in the first place.
Well, I get that.
And one does see arbitration awards that...
No, well, no doubt. But the question that we're concerned with is the 9.4 question, which is about whether the arbitration clause only, is void as a result of the effect of because it's unfair. That's not. No one is suggesting before us that that's to be ruled under the US law. So it's not. I don't understand why it matters. Why the US approach to fairness is relevant, because it's not being set up as being the reason why the arbitration clause is unfair, and therefore why there shouldn't be a stay. What's being said is the arbitration clause is unfair, and that's why there shouldn't be a stay, because it's contrary to the consumer test.
Or is it one of the three arguments in New York that one, the arbitrator should apply the English CRA protection under English law. Two, I'm a consumer under JAMS and you don't comply with the procedural rules. Three, the whole matrix contract is unfair and the arbitration clause is unfair. So that those 3 points are being advanced, but you don't accept that the arbitrator will apply the first of those.
Right.
So that as we see it at the moment, looking prospectively, there is a risk, to put it at its lowest, that the CRA unfairness protections won't form part of the arbitrator's competence jurisdiction. Is that?
There is that risk. But
is that a summary?
there is that risk, and as I said earlier, it may be a factor to take into account, but it's not a significant one in the context of the overlap of the issues. For example, page 107, supplemental that we looked at yesterday in the tribunal's ruling on the motion, whatever factual arguments the respondent raises about his knowledge of the terms of use, their fairness...
Hang on, sorry, you're going to have to wait till we get there. 107.
Yes. Whether they are... So, bottom paragraph.
So that's my fault. Where are we going? Just give me the reference again.
107 in the supplemental, please, tab 11.
Thank you.
whatever factual arguments the respondent raises about the knowledge of the terms of use, their fairness, whether he effectively agreed to them, which encompasses the arbitration agreement, whether they are unconscionable or inconsistent with his rights under English law, and whether the auction rules were deceptive or unlawful, cannot be resolved on the instant motion. A fact the respondent implicitly acknowledges when he states that if this proceeding is not stayed, the arbitrator should set a briefing schedule for a hearing on the complex issue of arbitrability. So there are wider issues there as to the unfairness of other terms which don't arise under Section 9.4. But those wider issues encompass an analysis of the fairness of the arbitration agreement, both under unconscionability as a doctrine of New York law, which is referred to in the Hornley article, which says the differences between consumer protection under New York law and English law, ultimately probably just a question of degree and maybe converging. And also the suggestion that they're inconsistent with his rights under English law, which may be applied, but I don't concede will be. And what we do say is that the Section 9.4...
Well, it goes a bit further than that, doesn't it? Would it be fair to record your client's case as being that they shouldn't be before the arbitrator?
I don't have instructions on that, and I haven't seen all the documents in the arbitration. I can take instruction on whether that has been our case or would be, but what I've been keen to do is not make that a fait accompli.
No, I understand that.
But the key point here is I say it's a fallacy to make decisive under Section 9.4 the question of whether the New York Tribunal will apply identical fairness tests. Rather, one looks at a more open-textured question. One characterises the issue as to the unfairness of the arbitration agreement, which may then be addressed by reference to different particular arguments, the JAMS minimum standards instead of the CRA section 64.2, or perhaps as well as. But what one mustn't do is say, without a cast iron guarantee that the consumer rights analysis application will be implemented by the arbitrator, we must have a Section 9.4 trial, and we say that would be wrong in principle.
Would you accept if it's not a bright line slam dunk point? I mean, it's a potentially weighty factor. I mean, I'm looking at the judge's paragraph 109, I have to say, when I'm trying to sort of get my head around this argument, where the judge seems to accept, first of all, that... Sorry, I'll let you get paragraph 109 in front of you.
No, please continue, because I'm on my limit almost. Thank you.
And I think this is where the judge is dealing with this point, isn't it? A paragraph 109 that we've just been on at the moment.
Yes, that is...
But what the judge appears to do is just to sort of say in the middle that the questions of fairness rather than technical questions of English law. I'm not sure what technical things she means. What's technical? I frankly regard the Consumer Rights Act as pretty technical. But it's not just sort of fairness as a free-floating concept, but she seems to treat fairness as a sort of fairly free-floating concept, well, sort of some sort of concept that sits in the middle of the Atlantic. I mean,
well, and we say that's consistent with our submissions, that one, parochial may not be the best word, but one cannot approach it in that blinkered way. If one had a Section 9.4 comparison where the courts of nation X were just not going to consider fairness at all, then...
What do you mean by fairness? That's the problem. You see, you can't just use fairness as a sort of mid-Atlantic concept. The fairness we're talking about here is a specific set of rights under UK statute, informed by English public policy, EU policy, in fact.
Well, we say it shouldn't be, because the comparison is between how things will play out here and how things will play out in New York. So one must also take into account the doctrine of unconscionability under New York law, for example, which is addressed in the Hornley. I mean,
but if you meant, if by fairness the judge should have stuck to the issues of English consumer law that she identified in the first line of the bit, I'm not sure how she could reach the conclusion she did in the last line and a half of that paragraph. I think that's what we've been underlying this debate we've been having.
Well, I accept that there are two possible interpretations of paragraph 109, and insofar as it's not as clear as it might be, that could reflect that the section 71 point wasn't there or wasn't front and centre, depending upon the recollection. But what I do say is that the result is correct for the reasons I've given, in that the comparative law analysis can't be foreclosed at the conflicts of law stage.
But again, if we look at 110, certainly at the end of it, no evidence suggests legitimate concern as to the ability of the New York court to address questions of English law, including matters of public policy. She seems to be proceeding on the basis that the arbitrator would apply the English law.
But
you don't accept that. She was wrong about that.
Again, I said that's one reading, but the previous phrase is indeed the applicable New York law, its ability to protect consumers. So I wouldn't accept that she was actually saying that it's necessarily going to be the case that the arbitrator applies every aspect of New York law and every aspect of English law. But, I mean, if I could just leave one further set of references on this overlap, because the overlap is important. And it's important both in terms of the consumer protections in New York, but also in terms of the key burrito factor. In the motion to dismiss, which is in the supplemental bundle at tab 12, starting at page 125, one has the four grounds put forward. And in particular, that the tribunal has no jurisdiction over Mr. Soleymani with respect to the subject matter hereof.
Supplemental page
125?
Supplemental
bundle. Oh, sorry, facts rather than authorities.
Yes, that's the first page of the notion.
Yes, notice of motion to dismiss.
Okay.
Mr. Soleymani in New York
I have you. Got it.
in January.
Four
In
grounds.
particular, page 138. The purported terms of use are not a validly formed contract. As a threshold matter, we see lines 24 to 25, page 38. The terms of use on which Nifty Gateway relies to compel arbitration is not a validly formed contract to which Mr. Soleymani may properly be bound. Over the page, there are two common types of electronic agreement, click wrap and browse wrap. It then goes on to rely on New York law and say that this agreement was a sign-in wrap agreement at best. And then on page 140, the factors to consider. So these are things that the New York arbitrator is being told to consider when deciding whether the terms of use are applicable for the purposes of that threshold question of the arbitration agreement being binding. Item 2, whether the design and content of the website, including the homepage, make the terms of use readily and obviously available to the user. 3, whether the importance of the details of the contract obscured or minimised by the physical manifestation of assent expected of a consumer seeking to purchase. 4, whether the merchant clearly draws the consumer's attention to material terms that would alter what a reasonable consumer would understand to be their default rights when initiating an online consumer transaction, including the right to bring a civil action in the courts of their state. It's not identical to item 20 of the grey list, but it's similar. A no to factor 1, 2 or 4, or yes to factor 3 will tend to support a finding that the contract is not enforceable. So we don't have the CRA fairness test being invoked in this particular motion, although there is a separate attempt to invoke it, but we do have very similar considerations being invoked in New York. And that is what weighs in the balance when one comes to section 9.4. And
those are all what I might call the good faith parts of the unfairness test rather than the imbalance part.
Item 4 might be both, but broadly yes. And the last point, as I overstretch, is that the Hornley article I mentioned, supplemental authorities bundle, tab 12, page 150. They deal, having dealt with English law, they then deal with contracts of adhesion under US state law, and the relevant section is 151 to 154, which sets out the doctrine of unconscionability under New York law, which has been invoked by Mr. Soleymani.
Well, I think we need to be a little bit careful about the status of this. If you're asking us to take this as an authoritative statement of foreign law, well, I'm not saying it's necessarily wrong, but it's not in the format one would usually expect for foreign law, in which you're asking the court to determine something.
I accept that. My learned friend mentioned it yesterday as justifying why New York law could not be trusted.
Well,
fair.
Sorry if I didn't jump in.
And I say the contrary. I'm with apologies, particularly to my learned friend, unless there are any questions. There's my submission.
I think there's one point on which we might like to hear from the CMA at this stage, and it's this. You haven't seen it as any part of your function, really, to address ground 1, and I just wanted to see whether, on a point that does arise in relation to ground 1, that the CMA had anything to say, and it's the point that I was putting to Mr. Dunning, that what is said to be the myriad adverse consequences for consumers generally may be minimised, if not completely extinguished, if the consumer has the opportunity to vindicate his substantive rights at the place of his domicile by seeking a claim in relation to substantive rights, or if need be, declaration of non-liability. And then section 9.4 does the work of enabling the English court to apply the CRA protections if they apply. And our Lord Justice Birss has pointed out that there may be a gap in that respect if it's necessary or desirable only to be able to have a decision on the arbitration clause's validity or not, and that's dependent on whether the other party does seek to invoke section 9. But did you want to say anything more about any gaps or insufficiency in consumer protection in that context?
Very little, my lord, but if I may trouble you.
Yes.
I'm grateful for the fact that you have picked up and highlighted the concern that the CMA has about the potential for the judgment below to undermine consumer protections afforded by the Consumer Rights Act. And that was the reason why an application was made to intervene, which my Lord Justice Birss was kind enough to permit. And we were particularly concerned, CMA, about the situation in which overseas traders could insert clauses into online contracts which are entered at the click of a button that could in some way jeopardize the significant protections that are now afforded by domestic legislation to consumers in the UK. And that's the concern that we had. I don't know. We were therefore rather reassured, I have to say, as matters developed yesterday, to hear your Lordship's point about the way in which consumers, certain consumers, could take advantage of procedures that are available in this country in order to stand on those rights, because we had been concerned that the corollary of the judgment below would be the opposite message. So the point that I wish to make, if I may, and ask this court is to, if it felt it appropriate, to make that point in any judgment that might be handed down, so as to provide some reassurance to those who perhaps don't fall into the same camp as Mr. Soleymani, that is an option for them in future. We do, however, we are concerned, as my Lord Justice Birss pointed out, at the situation in which you cannot make a direct challenge, if that be the case, and that be the decision of this court, against the fairness of a foreign arbitration clause in a compulsory online contract. And we do remain concerned for those individuals who might be affected by that anomaly. It's not my part to enter the fray in this appeal. We are grateful the CMA to be here, and we are grateful that the court has taken into account the submissions that we have made. But we do highlight a continuing concern, albeit perhaps not the concern that brought us here, but a continuing concern about that group of consumers. There is a little bit of reassurance, and it comes from my learned friend for Nifty's skeleton argument, that again, as Lord Justice Popplewell pointed out, there are other gateways that might be available in other circumstances. And so there may well be gateways, particularly the contractual gateway, which consumers could take advantage of if they wish to bring proceedings in this country to avoid the pitfalls that Mr. Soleymani is dealing with here.
But will that be likely in a case of a online purchase of an NFT?
My Lord, not if there is no delivery here of the goods, because if one is taking advantage of the contractual gateway, one would be looking, I think, as a minimum at delivery in order to be able to afford some form of cause of action based on delivery.
But a consumer who enjoys the receipt of goods or the enjoyment of services in this country will come within the gateway.
My Lord, yes.
Under place of performance of the contract.
And I may be being rather cheeky in asking this, because it may not, the court may feel, fall within its aegis in this appeal. But given that the importance of your judgment in relation to consumer protection matters, if it were recorded, or that possibility, that option were recorded as well for consumers, it would provide welcome clarity. Those are the submissions that I would like to make, if I may, in response to that kind of question. Apart from that, I don't think I can add anything on that issue.
Do you have any observations on the situation that Lord Justice Birss asked about, of the person with a claim under under £5,000, I think it is, where the amount involved is under £5,000, and as I understand it, an arbitration clause in such a contract is not just on the grey list, but
on the black
is on the blacklist.
I've characterised, forgive me.
Yep. How does that play out?
Well, it presents a significant difficulty for that consumer, particularly in cases in which a consumer is, as your Lordship was saying earlier on, contracting online and perhaps not receiving goods in this country. So a dispute for under £5,000 in that situation presents a consumer with on the law as it may stand, and your lordships may find it stands, a significant difficulty.
Unless it brings a claim for a declaration of non-liability as well.
And unless that be the case, one of the reasons perhaps why there is this limit is to recognise the proportionality of litigation, in cases where the value of the dispute is less than £5,000, not having a very clear remedy is difficult.
Well, as I see it, the difficulty that's highlighted by that is that that's the very person which the legislation seems to want to protect most of all, because it's just completely offside to have an arbitration clause. It's a blacklist. But it's that person for whom actually bringing proceedings to seek a negative declaration of no liability in order to avoid what's happening in an arbitration abroad is going to be most onerous, because it, frankly, they're going to incur significant costs in actually having to do that against what for them may be quite a high level of expenditure, a high level of liability in an arbitration, and I can't square that circle at the moment.
Your lordship's made the point far better than I was trying to make. Exactly that, which is why in my submissions, in our submissions, we indicated that we saw a huge amount of force in the policy submissions that were being made on behalf of Mr. Soleymani, even though they there are particular difficulties with the way that the law your lordships may find the law may stand.
But the consumer who has a £4,000 claim and is faced with a foreign arbitration has a difficulty anyway in that if he wants to get an anti-suit injunction, and he's able to, he's got to spend quite a lot of money coming to this court to do it. There's no perfect solution. But what I wanted to ask you is what's the rationale for the under 5,000 being on a blacklist? Is it because that's the limit of claims which can be pursued on a no liability for costs basis, and therefore an arbitration in relation to those is necessarily unfair because it exposes a consumer to a potential
Lord,
liability to costs?
I'm afraid I can't give you an answer.
Why is it on the blacklist as opposed to the grey list?
Again, I'm afraid I can't give you an answer as to why it is there. It is a provision of some, not antiquity is the wrong word, but it's been around for some time. And the £5,000 limit, I think, is some 10, 15 years.
I think it was part of the Arbitration Act when it was enacted in 1996, wasn't it?
I think it was five.
The figure may have been different, but there was a.
I'm helpfully told by Ms. Welsh it was £2,000 and they went up to £5,000. I'm afraid I cannot help. I can actually take instructions though and provide the court with an answer to that in writing if that would assist.
Speaking for myself, I would find that helpful.
I'll do my very best to do that.
It's not the small claims limit, at least not now. It hasn't been the small claims
No,
limit.
for quite a long time. No.
I'm told that the change to £5,000 may well have been in 2009, and it may well be possible to trace back through CPR and look at the small claims limits over time to see whether or not that figure has any relevance to any other figures at the time.
And there may be something in the DAC report prior to the 1996 Act, if it was a part of the 1996 Act.
Well, Lord, I'll
So
undertake.
perhaps I could ask you to look at that as well.
I'm happy to make those inquiries. Lord, there was only one other point that I've been asked to raise, if I may, which is following on from some submissions made by my learned friend Mr. Dunning yesterday in relation to my skeleton argument. Right at the end of my skeleton argument, paragraph, if I can take you to it.
Is this the non-delegable duty point?
No, I wondered whether you might ask me about that, but you haven't.
No.
It's the same paragraph, however, paragraph 41, over the page, thankfully, from that sentence. I said this, in summary, the court in this case, like the judges in the cases highlighted in paragraphs 21 and 22 above, had sufficient legal and factual material to decide the issue. The chronology of my skeleton argument is that it was put in soon after the appellant's skeleton argument was lodged, but before the respondent had filed their skeleton argument. It was prepared on the basis of just seeing the appellant's skeleton argument and reading the judgment. I was very grateful for copies of those documents. And it was put in fact, before we had permission. That sentence, therefore, reflects the situation as I saw it at the time, and I hadn't appreciated at that time that my learned friend, Mr. Lewis, would be raising various other issues about the issues that would arise on a Section 9.4 trial.
So are you now neutral on that issue?
I am now. I'm instructed to be neutral.
Thank you.
So since my interest has now been piqued by your reaction to the first bit of paragraph 41, do you stand by what you said in the first sentence of paragraph 41, starting at the bottom of page 95?
I do. I do. And I use the word non-delegable duty, perhaps borrowing from another branch of the law, not using it as a term of art, but I am expressing clearly what the CMA considers to be the position under Section 71. My learned friend used the phrase ex officio. I'm not sure there's a huge amount of difference. It is the obligation that arises under primary statute, Section 71 of the 2015 Act. It's an obligation that arises and is imposed upon the English court. I do therefore stand by the first sentence.
Thank you. Mr. Dunning.
Very great.
My Lord, I mentioned yesterday certain matters that my client would undertake, and your Lordship suggested I should put that in writing. I have put it in writing. I've shown it to my friend Mr. Lewis. He doesn't have any comments on it, and I can either hand that up or we can simply circulate it by email through your clerks.
Probably more convenient to circulate it by email.
Yeah, exactly.
Thank you.
If I may, I'm going to be as brief as possible and just hit some key points. But on jurisdiction, first of all. The big question is this. If a consumer relies on his statutory consumer rights to plead that he is not bound by an arbitration agreement, is the correct characterization of the substance of that claim consumer rights, or is it arbitration? Now, in one sense, I know we talked about Venn diagrams, but in one sense, the law requires a binary decision to be made. Is it within or outside the arbitration exception in those circumstances?
It's not just any consumer rights. It's the consumer right
I know, I'm going to come to the
arbitrate.
specific rights in a moment. I will come to the very specific rights in a moment. But I'm trying to at a very, very high level, picture the point on jurisdiction. The specific consumer rights, my lord, that we say are relevant here are threefold. And this is in the pleading. These are all form the basis of the pleading. Three elements of the consumer rights here that are relied upon. Firstly, the right to sue and be sued here under section 15b(2) and 3. Secondly, the right not to have those first rights taken away by a pre-dispute agreement under 15b(6). And thirdly, the right to have a term which falls within paragraph 20, grey list, part 1 of Schedule 2, declared unfair under the CRA and not binding. In essence, those are the three rights that have been pleaded and which form the basis of the claim. So subject to that, the question is the correct characterization of the substance of that pleaded claim that it's a claim in respect of consumer rights, or it's a claim which falls within the arbitration exception? And we say that...
Or both.
I'm sorry?
Or both. That's Mr. Lewis.
Well, no, it isn't both. It can't be both inside and outside the
No,
arbitration
but it can be a claim to vindicate or protect consumer rights, which are only consumer rights not to have to arbitrate, and are therefore solely concerned with arbitration. I know you've characterised them in the way that you've rather carefully not referred to arbitration, but referred to a pre-dispute agreement. But if one's looking at the substance, the case that's put against you is these are all rights which you say go to the relief that you're seeking under the arbitration claim, namely a consumer right not to have to arbitrate the dispute.
Look, this is the
and
question.
It is the question.
It is
But that's why I'm
I was
putting.
trying
That's why
to
I'm
phrase
putting.
it as neutrally as possible.
Well, that's why I'm putting to you that the point you've got to grapple with.
Well, that's
is-
Mr. Lewis's point.
It's
That
Mr.
it
Lewis's
is
point,
enough if
and
it's-
you've slipped by it by saying it's one or the other.
No, but I don't agree with him. It is a binary decision. Is it inside or outside the exception? And the current authorities have the test in paragraphs 71, 74, Prestige numbers 3 and 4, which we looked at yesterday. Won't go back. There are 3 or possibly 4 ways that the test is expressed. But the answer is a binary. It's a binary decision in the end. Is it within or outside the...
That's a binary decision, but the characterisation is not necessarily binary between, on the one hand, consumer rights and on the other hand, arbitration. That's the point
But ultimately, there's only one question of characterisation that's necessary. That's my point. And that is it arbitration or is it not arbitration?
Is it
because it is consumer rights.
Is it consumer rights but not arbitration? Put it that way.
Yes. Is it is the subject, the substance of the claim, is the substance of the claim arbitration? Let's put it that way around. Is the substance of the claim arbitration, or is the substance of the claim not arbitration because it's the enforcement of consumer rights? Yeah. I mean, another way of putting it might be to say, we all know it's a consumer rights claim about an arbitration. No one has any problem with any of that. The question for the purpose that we have to decide is which of those two things is the relevant factor when applying the jurisdiction question under the regulation. And it is binary in that sense. There's only one of them. That's what I was trying to say, because I started by saying if a consumer relies on his rights to plead that he's not bound by an arbitration agreement. I wasn't trying to get rid of the arbitration agreement, but ultimately the question is, looking at the arbitration exception, does this case fall within it or not? Because we say that it's to do with the enforcement of consumer rights. And the rights in question are the rights to sue and be sued in the English courts. And those rights, we say, are infringed by the arbitration agreement, which we then say is either contrary to CJJA or contrary to the CRA. So I didn't want to, I'm just trying to capture the point, and we respectfully submit that we are correct on that point. Now there are various ways you can test it. One is Lord Justice Birss's example of the slam dunk invalidity case to under £5,000 because it's on the blacklist. You can test it that way. But what about another way of testing it? Let's just ignore for one moment the international context and just imagine that there's an entirely domestic case and a consumer is faced with a trader who says you're bound to go to arbitration in respect of this NFT contract, let's say. Now, in the ordinary way, it would be perfectly proper for that consumer to commence proceedings for a declaration that he's not bound to arbitrate. This is in the totally domestic context. And there would be nothing improper or wrong about that. It would be a valuable declaration because if the courts declared that the consumer was not bound to arbitrate, he could take that along to the arbitrator and say, look, here's the decision. I'm not going to participate in this arbitration. The courts have declared that I'm not bound to arbitrate. And in that situation, the consumer would not be bound to plead a claim of non-liability in the hope that there would then be a decision
under section 9.4, he would be acting perfectly properly and within his rights to claim from the outset a declaration that he is not liable to arbitrate the dispute. In effect, seek a declaration, I am not bound to arbitrate. Now, let's assume that's all true in the entirely domestic context. It would seem slightly surprising, to say the least, if the consumer does not have that right in an international context. Because in an international context of a foreign arbitration against a foreign party, he may need that protection all the more, particularly if the foreign arbitration is not going to recognise his statutory English law consumer rights and is going to subject his liability to some other law which he incidentally says was also unfairly imposed upon him, contrary to his consumer rights. So it would be surprising if that was the case, that in an international context you can't seek such a declaration. Now, that's what this judge has held. So although a consumer may have a perfectly legitimate interest in wanting a declaration of invalidity of an arbitration agreement, it cannot get one in international context. And in this specific context, absent goods being delivered in the UK and so forth, it seems that myself and Mr. Lewis are agreed that none of the other gateways will apply to a case like this for disputes arising from transactions on an NFT platform. And I hope I've already said enough yesterday to satisfy you that the NFT market is huge and getting bigger all the time. There are thousands and hundreds of thousands of UK consumers. And just on the point that I was asked about yesterday, I have taken detailed instructions on Lord Justice Snowden's question, well, what sort of price is paid in this market? And the answer is that transactions can range from $1 to millions of dollars. I'm told many NFTs sell for $50 or $100. Probably in terms of the number of transactions, that's the vast majority. But equally, they can sell for any price between $1 or $50 or millions of dollars. And we don't have to just go on the basis of me saying this. We do actually have the indications from the auction in this particular case. I know it's not been put in the bundle, but it was an exhibit, and both parties have had that. Now, we know, therefore, from that what the 100 highest bids were, and all the bids, I'm told by those who've looked at it, from the 61st highest downwards were at or around $36,000 or lower. So roughly 40% of the bids were 36,000 or lower. They weren't all sky high. So this is a big market. Hundreds of thousands of UK consumers are involved in this market. And so it's a jurisdictional question of potentially very wide import. And I'm not going to repeat everything I said yesterday, but we say it is properly characterised as a question of consumer rights, not of arbitration, and it doesn't fall within the arbitration exception. And we say two things in relation to that. I said this yesterday, but I'll perhaps make it a little bit clearer. We say that my submission works perfectly well under the existing EU law based on the 3 or 4 tests which this court applied last year in the Prestige numbers 3 and 4. But we have looked again and thought again about 15A2, and we looked in particular at the explanatory memorandum which we sent to the court. I know the court has had. And I just wanted to underline 3 or 4 points, that most of which I made yesterday. Well, there's one point I didn't make yesterday in this regard. And that is, the court doesn't have to apply the EU approach anymore. It can approach 15A2 and the arbitration exception as it would approach any other English private international law point. And that is because section 15E2 tells us that the court does not have to have regard to CJEU case law for the purposes of Chapter 1, which includes, obviously, Article 1.
But it does have to have regard to Schlosser paragraph 37.
If relevant.
Sorry, 64.
If relevant, it says. And now, if you're not applying EU case law, you might take the view that it's not relevant. So what is hidden in those words, if relevant, is not very clear. But if you go down the route that I mentioned yesterday by reference to my skeleton argument, I think shortly after the short adjournment, private international law would adopt a characterization approach and would look and would say, what are the rights which the claim is seeking to invoke? And that would support my argument.
Wouldn't it ask what the issues are?
We'd ask what the issues are. Yes, that's another way of putting it. Raised by those. What are the issues raised by the pleading of those rights? And the issues are.
Is an arbitration clause invalidated by consumer legislation? Or you might turn it around and say, does consumer law invalidate an arbitration clause? I mean,
I know, well, that's why I say this is the question that's got to be decided. But as a matter of policy, it is surely more important to protect the consumer and to the court to assume jurisdiction than to decline jurisdiction. And I know that Lord Justice Snowden yesterday was worried about what about cases where there's an attack on arbitration clause by reason of mistake or fraud or something like that. But it needs to be, and this is the point I didn't stress yesterday, and we had a discussion which was on a slightly false basis. What has happened, and this is clear from the explanatory memorandum, is the whole of the recast regulation has gone now. It's no longer part of English law, except for the provisions in relation to consumers, employees, and some provisions relating to, I think, the seat of a company. So nothing else, and that includes, by the way, all the insurance provisions that have been taxing the court in some of these cases. That's all gone. That's all no longer part of English law. So and all the tort provisions, contract provisions, prima facie has to be sued in place of domicile, all of that's gone. So nothing else of the regulation is left, it's essentially, apart from consumer cases under Section 15B and employment cases under Section 15C. And what happened is that I believe it was anticipated until very late in the negotiations that the UK would join the Lugano Convention, but it didn't happen.
Well, I think that was always in doubt.
Well, it was always in doubt because, and I imagine, because the UK wasn't prepared to agree for any appeals to go to the CJEU. And therefore, although the EFTA countries all agreed to the UK joining the Lugano Convention, I understand, the EU countries, led by France, didn't. And so we didn't join the Lugano Convention, and the recast regulation has gone, except for, essentially, these provisions in relation to consumers and employees. And that is, if I could just show you did you print out the explanatory memo? If not, I can just give you the relevant paragraphs to look at.
Yeah, I did, yeah.
But we may have some copies here.
All right, I've got it printed.
If you'd like a copy, hand it up.
I've got it printed.
Yeah. Just very quickly, I won't take you through all of it at all, but paragraph 2.6, post-Brexit, the Brussels EU Brussels regime will cease to apply in the UK. And then the bottom of the page, the last 3 lines, the exceptions to this approach relate to cases involving consumers domiciled in a part of the United Kingdom, employees who work or have worked in a part of the United Kingdom, and the retention of the definition of domicile of companies or other legal persons. The instrument has been adopted, and so the way that the change was made to the Civil Jurisdiction Judgments Act was by statutory instrument, which we have in the bundle. And it goes on and explains that in the regulation, including a right to be sued in relation to a consumer or employment dispute only in the part of the UK in which they are domiciled, regardless of the domicile of the other party, and a right to sue the other party in such a dispute in parts of the UK with relevant connections, all of which largely obviates the need for the consumer or employee to sue abroad in such cases, with the attendant expense and difficulty for this category of economically weaker parties, which having to sue outside their own forum brings. And then 7.1, there's a series of bullet points in 7.1, and I want you see the reference to them in the penultimate, the penultimate bullet point on page 6 retains and restates the rules contained in the Brussels 1A regulation relating to the jurisdiction cases brought by and against UK domiciled consumers, employees who work or have worked in the UK, and against employees domiciled in the UK. And then 7.2, on the same page, the effect of the above will be to remove the Brussels regime rules from domestic law, save for the retained provisions on jurisdiction in consumer and employee matters. And then 7.10 and 7.11 says, in 7.10, in relation to jurisdiction of the courts of England and Wales, Northern Ireland and Scotland, to hear consumer and employment contract cases, these regulations retain to a large degree the consumer and employee-friendly approach of the Brussels regime. And then 7.11, these regulations provide that in cross-border civil and commercial cases involving UK domiciled consumers, the consumer can sue the other party to a consumer contract, either in the part of the UK where that other party is domiciled, or in the courts for the place where they themselves are domiciled. It's the other party. If it's the other party for the proceedings, they can only do so in the courts of the part of the UK in which the consumer is domiciled. And then 7.19 deals with the rationale for retaining and restating these rules. And 5 lines down, the rules ensure that the consumer or employee should in general not have to sue or be sued in a jurisdiction which is unfamiliar to him in terms of, for example, language. These rules apply not only to suppliers or sellers and employers domiciled in the UK, but also those who were not so domiciled, and this approach is continued. These protective rules are not available in the common law and statutory provision of England and Wales and Northern Ireland, and only to a limited extent in Scotland, apart from the Brussels regime. And so the government has chosen to retain them. So that is the background. But in so deciding that, it was decided that in the future, to the extent specified in section 15E(2), the English law could go its own way in how it addresses these rights. And if, for example, you thought that you couldn't find that these were consumer rights applying the EU test, the old EU test, which I submit you can, but if the court concluded it couldn't do so, then I would urge the court to go in a new direction under English law, which it's free to do, because that would give effect to the public policy of ensuring that consumers can sue and be sued in their place of domicile. That's all I was going to say on jurisdiction. If I may just go on a little bit longer, my lords, just a few other points. I won't say very much about 15b6 and 15d1. Essentially 2 points. Of course I accept that 15b6 does not apply if the court concludes that the arbitration exception is applicable here. But my submissions are on the footing that the court has accepted my submissions on the arbitration exception. And if that is the case, then 15b6 does apply, and there is nothing in the wording of 15b6, or indeed in 15d1, but 15b6 is the main provision, which restricts its application to arbitration agreements. And it simply has to be an agreement which takes away the 15b2 or 15b3 rights. And it's just a matter of construction. Now, I'm not saying that, that we get into this if I lose on the arbitration exception, but if I win on the arbitration exception, then in my submission, there is the arbitration agreement is invalid because it was made pre-dispute and it falls foul of 15b6. And moving on then to the third aspect, I haven't addressed you on section 74 previously, and this wasn't something that featured in the judgment, or indeed in the respondent's notice, or indeed in my learned friend's skeleton argument. But he did address you at some length on section 74 today, and the close connection issue. What I would ask simply is that we've looked and we found a passage in Dicey, found a passage in Jitty, and maybe a case, we're not sure. But could we put in a note, say by the end of tomorrow, just attaching the relevant parts of Dicey and directing you to that, and Jitty, which seems to have a footnote which addresses the fact that Article 6 of Rome 1 is still there, notwithstanding section 74, which is contrary to Mr. Lewis's point. And if we do find a case, just mentioning what that case is, my lord, because I didn't have any notice of these points, and although we did our best over lunch, and I can certainly tell you that
I hadn't understood Mr. Lewis to be submitting that Article 6 of Rome 1 wasn't still there as a result of section.
Well, I think he said it was.
I see he's nodding, but
oh well. Well, if and then I may be pushing it an open door on that point. But what Dicey says, for example, is that although Dicey is somewhat out of date as far as I can see, because it's talking about some old provisions, but it's essentially the same. That directing activities, which I think was the point that Lord Justice Snowden picked up, or the domicile of the consumer, either of those could be an indication that the contract has a close connection with the United Kingdom or with England, because it points out that it only has to be a close connection. We say, of course, that we have both here. But so I would ask if we could just to put in a short note tomorrow.
Well, just
on section 74, because we had no notice that those points were coming, and I just on the close.
Well, if it's confined to the points that you've identified, I think what we need are the references in Dicey and Chitty you want to rely on.
So, my lord, subject to that, section 71(2) is mandatory. And as was said this afternoon, the learned judge did not take that into account in the exercise of her discretion. But if Section 71(2) is followed, then there will be, or should be, a determination of my client's rights under the English Consumer Protection Law by the English court. And that, of course, is inconsistent with delegating that decision to the arbitrator, even assuming the arbitrator was going to make a decision on the same points. And this is not Section 71(2) is not a feature that is featured in any of the previous cases which describes the court's proper approach to an issue under Section 9, subsection 4. So, although they are all very interesting and useful to look at, they don't cover the current situation. So that's the first point that we say the discretion is vitiated.
How much longer have you got?
Pardon?
How much longer have you got? Accurately, how much longer would you like to take?
I was just going to run through the points. I was going to say something. Well, I can take as little or I don't want.
Well,
to
if
be
it's
more than
repeating,
about 10
I mean,
minutes. I don't really
you,
want to be more than about 10 minutes, my lord.
all right. Well, I'd be inclined to give you 10 minutes and no more.
Okay. So just on the reasons why the exercise of discretion is vitiated, that's the first reason. Not paying sufficient weight to Section 71(2). The second reason is, well, there are two closely connected reasons, that in all likelihood, or there's at least a substantial risk, that the arbitral tribunal here will not apply English law, will not apply the relevant statutory protections under English law. But even if the tribunal does try to do so, it is going to be in nowhere near as good a position as the English court to decide the relevant issues, as Mr. Lewis has outlined them, of EU and English law. And we respectfully submit that the learned judge has erred on both of those factors. So in paragraph 112, she said there was no evidence that the English law points could not be raised in the arbitration. But that's rather beside the point. It's the question of whether they would be determined in the arbitration. And in paragraph 109, she said the English judge is not significantly better placed than the arbitrator to decide the English law points, and with great respect, we think that's plainly wrong. So as a result, the decision to refer the issues to the arbitral tribunal is tantamount, we say, to depriving my client of his right to have those issues of English law determined. And they are subject to Section 70, mandatory provisions of English law. And that's why, it's a third reason why her decision is an unfair one. Fourth point, and this came out of the...
Sorry, what's the test? I don't want to delay you. You say unfair. I mean, you just...
Well, she says it wouldn't be unfair, and we say it would be unfair for the reasons I've just given. Then the phrase came up, Mr. Lewis used it, precedent value. And it is the case that in this consumer protection area, the fact that a hearing and a determination by the court may have precedent value is because of the public policy background to consumer protection, is another valid reason why the court may decide that it's more appropriate for these points of consumer protection to be decided publicly in open court by an English court rather than privately and confidentially by a New York retired judge in a New York arbitration. And the precedent value, as we've heard from my learned friend, Mr. Riley Smith, is really part of the reason, or the main reason, why the CMA intervened in this case. And so far as the overlap point, as I made my submissions before, the claims should have always been brought here as a matter of English law, and we are certainly prepared by the undertaking to ensure that all issues are decided by the English court.
The undertaking you're going to send us by email rather than hand up now.
I can have it,
but if you'd like it handed up now, we can hand it.
I just think I hadn't seen it. Just checking I missed it.
No, we haven't had it yet. But
No, you haven't had it yet.
no, but we're going to see it.
My learned friend saw it this morning. He said he had no comments on it, so I'm very happy to hand that up.
On the basis of the matter between the defendant and the court, rather than on the basis that we support.
But it's an undertaking that's being offered. You've seen it. You say it doesn't make any difference. Is that fair?
Well, fine.
I assume. Thank you very much.
I think the only other thing that I wanted to just draw out to your attention is in relation to the test of unfairness, which has got the two components of the significant imbalance and contrary to the requirement of good faith. Mr. Riley-Smith very kindly prepared that note which you had, and which attached to it the Aziz case as well as the Cavendish case. And I just wanted to take you to the, because this came up yesterday in the context of whether or not the factors were objective factors or not objective factors. Take you to the Aziz case, the passage that Mr. Riley-Smith has referred to, which you have it in a separate bundle, and it's page 12 of the report. The bundle itself is not separately numbered, I believe. And
You mean 12 in the middle of the page or 10 at the right-hand side?
12 in the middle of the page, 10 in the faint numbering on the right. And then picking it up at 68. The passage starts at 66, but I was just going to emphasise some of the bits of it. At 68, as stated by the Advocate General in point 71 of her opinion, in order to ascertain whether a term causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer, it must in particular be considered what rules of national law would apply in the absence of an agreement by the parties in that regard. Such a comparative analysis will enable the court to evaluate whether, and as the case may be, to what extent, the contract places the consumer in a legal situation less favourable than that provided for by the national law in force. To that end, an assessment should also be carried out of the legal situation of that consumer, having regard to the means at his disposal under national legislation to prevent continued use of unfair terms. And the point I was going to make is, it may not be the right adjective to use to say that those are all, that's an objective consideration, but that's essentially a legal analysis. It doesn't depend on specific individuals and facts. And then in 69, there's the test which we did discuss yesterday, right at the end of paragraph 69, in considering the imbalance question. The question is, could you reasonably assume that the consumer would have agreed to such?
No, that's in considering the good faith requirement, isn't it?
Oh, sorry, yes, that's the good faith requirement. I'm trying to go too quickly. Could reasonably assume the consumer would have agreed to such a term in individual contract negotiations. And then at 71, further, pursuant to Article 4.1 of the Directive, the unfairness of a contractual term is to be assessed taking into account the nature of the goods or services which the contract is concluded by referring at the time of the conclusion of the contract to all the circumstances attending the conclusion of it. it follows that in that respect, the consequences of the term under the law applicable to the contract must also be taken into account. So there is a linkage with the applicable law point, and that's why it's been pleaded in the way it has by my client. And those are the passages I wanted to particularly draw your attention to. And then in Cavendish, the leading speeches were Lord Newburgh and Lord Sumption. And this is page 73 in the numbering of Cavendish at the bottom of the page. And just to draw your attention to the fact that they started around letter D on page 73, referring to Aziz. And then saying, just below the letter E, the judgment of the Court of Justice is authority for the following propositions. And at 2, for example, the question whether there's a significant imbalance in the parties' rights depends mainly on whether the consumer is being deprived an advantage which he would enjoy under a national law in the absence of the contractual provision. In other words, this element of the test is concerned with provisions derogating from the legal position of the consumer under national law. However, provision derogating from the legal position of the consumer under national law will not necessarily be treated as unfair. The imbalance must arise contrary to the requirement of good faith. That will depend on whether the seller or supplier dealing fairly and equitably with the consumer could reasonably assume that the consumer would agree to such term in individual contract negotiations. And then in 4, taking into account the matters referred to in Article 4. And in addition, at paragraph 106, they referred to the court drawing heavily on the opinion of the Advocate General. And just below the letter C, I'm taking this very quickly, said, in determining whether the seller could reasonably assume that the consumer would have agreed to the relevant term in a negotiation, it's important to consider a number of matters. These include whether such contractual terms are common, to say they're used regularly in legal relations in similar contracts, or are surprising, whether there's an objective reason for the term, whether despite the shift in the contractual balance in favour of the user of the term in relation to the substance of the term in question, the consumer is not left without protection. And then just below the letter G, finally, the Advocate General observed that the impact of the term alleged to be unfair must be examined broadly and from both sides. Now, there is then a very long discussion in Chitty, which my own friend Mr. Riley Smith also put in, but I'm not going to take you.
You've had a little more than your 10 minutes now.
Exactly. And my lord, unless I can help you any further, those are my submissions.
All right. What we're going to do is to rise for a moment, to ask you to stay here, and then we'll see what we've got to say to you when we can come back. I expect it'll take us 10 minutes or so, but we'll see.
All right. No, no, it doesn't talk about. I mean, basically, committee he was writing it, wash the hands of it, because it was all consumer. now when it's yeah, then it wouldn't sound fine. But you're talking about small claims.
Oh, I see the small claims.
So there's a small claims provision as well, so that may be why it's confused. And then also, there's two DAC reports, and the original DAC reports, the Hansard reports, where it's discussed why judgments upon that account ground and any user-friendly way. They're revising the Act at the minute. Well, that's done under regulations, so they don't really, they would probably wouldn't be the correct mechanism, but to the extent any of the drafting issues need to be fixed around that's something that should be put on the radar for the Law Commission and I'm so glad you do.
No, you're quite right.
I was just saying that I just checked what the which I think exactly the same. They basically wash their hands of it and say
What?
in the DAC reports, they're just saying, listen to us, we haven't scrutinised it.
The DAC.
Yeah.
Was it in the
Yeah, there was a foreign consumer, there was a consumer contract, Consumer Arbitration Agreements Act 1988, which they then folded in. And what they say in the DAC report is there was previously a distinction between foreign and domestic that no they got rid of that arbitration.
Yeah, well, there wasn't state. Yeah, state. That's discretionary state. Yeah,
So,
but unfortunately,
why, come back in?
Yeah.
Oh, is it?
Someone has it?
Nah, they didn't say nothing to me. So you still, yeah, I'm see it.
Thank you so much. I'm sorry for a ridiculous email. Really early.
No, no, it's fine. It's fine.
We just realised that thanks for the same vote.
That's
So
okay.
we're watching it on stream.
All right.
The computer went
So they're coming back in.
Thank you so much. It was really good.
How is it? So you're not finished? No. I was there. I wasn't listening. I was just watching.
Exactly what I was doing.
What's the ego?
See you soon. I've got to change. I've got to get to you. No, I'm also doing with me. I need to get to Euston for 6:30. No, that's fine.
Don't be afraid.
No, no, it's fine. And also what they want is thinking.
sheets of paper.
We're very conscious that the hearing has been expedited because of the September date. We propose to reserve our judgments. We are giving some thought as to whether there are any aspects of the issues on which we can give you a decision now with reasons later, and we consider that if there is any aspect on which we can do that, it would be better if we indicated that in writing, and you had it in writing, and therefore we anticipate that we will let you know in writing tomorrow whether there is any aspect of the issues on which we can give you a decision now for reasons later. Thank you all very much. That's not only aimed at those in the front row, we all know who has to do the heavy lifting in these cases. When our judgments are handed round, they'll be circulated in draft in the usual way. We're all conscious of the recent decision on the importance of sticking to the embargo. You're all conscious, I know, that returns are not for re-arguing points, but just for editorial corrections. We'll expect the parties to seek to agree an order and to put arguments on any consequential matters in writing. We haven't had any more from you on cost schedules, so we'll extend the time until 7 days from today's date in relation to those. And when the judgment's handed down in final form, it'll be done in the way that's usual now, with no requirement for anybody to attend. Thank you all very much.